We shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
Lord, for the fifth interest, for the first interested party.
Mr. Lord, just a minute. I was about to interject when when Council,
The Gachagua?
yes, Mr. Debwa was addressing, and that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Debwa, after all that, what is your application?
Your Lordship, I'm very clear in my application.
My application for which
the application can only come after I have spoken.
we are now making an application. You respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is making an application before this bench complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Muigai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes.
My lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, and Edward and my friend Kibe, is that you are taking the court for a long ride and you are ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you say? My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My lords, if it pleases the court, my name is Ramja Mohi. I am acting in person. We filed an application for certification of LLC on the 8th of October, 2024. Before this bench was impaneled on the 14th of October, 2024. Unfortunately, some of the cards we were seeking have been overtaken by events. My lord, if there is a card, our application has not been placed before you, and we are just concerned that our application will once again, investment and once again overtake our application. My lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Secretary, for the 15th interested party in 15, may I just be heard for 1 minute only. I know that we asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Bremer about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity to sit, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. Yes. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is the lawyer applying for an adjournment? Because he's saying, and perhaps rightly wrong, that even the recusal application comes after the termination of the question when panel. If that be so, they normally leave court, they may leave the Senate, may leave court. Let them say whether they are trying to adjourn.
Is that remark, they normally leave court, the left Senate palatable in this court, my lord? I need that answer first. No, is that remark palatable before my lord and my lady? My lady, because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem in withdrawing the remark. But the point is, it is a veiled application for adjournment. Because Mr. Moyle is saying that the court must address the question of empanelment before the recusal. So I can just make the point.
I am answering the question now, but I know that he has withdrawn. He said he has no problem withdrawing, but I didn't withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem withdrawing.
No, my lord, you must withdraw.
I withdraw the remark.
Thank you so much. Thank you. Thank you. Let me now address the question as addressed. My lord, Professor Jenda was my teacher and my mentor of many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues Kibe Mungai and learned colleague Mr. Ndegwa that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Gideon Muigai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again now how to move forward.
We're speaking for too long. Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light just now. They actually knew of it, and they would have found out. The letter which was written this morning, which it was written on the 20th of October, as actually one pertinent question. It is posing whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. That we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. That as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fluxion of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner's side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
mwenzangu, hapo kulikuwa ni mahakamani Milimani ambapo hatma ya Gachagua kotini ilikuwa inasikilizwa, na bila shaka imekuwa ni muda wa taifa kuweza
Which files, one by one, are before this honor?
Senior Counsel Paul Mute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us to talk. So I've heard.
Thank you.
Because if everybody's going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit for this morning, for the purposes of hearing this morning, and the applications which are before the
ama pia wale
court.
Kwa sababu alikuwa na watu ambao wanamfanyia kazi yeye.
Naam.
Je, walikuwa wapi wakati huo ambapo alikuwa na wasiwasi kwamba kuna mtu ambaye alikuwa na nia fiche ya kumwangamiza?
Naam.
Ripoti hakutoa. Yeye mwenyewe katika ile kupitia article 238 ya katiba ibara 238 anaketi katika National Security Council.
Naam.
Alitoa taarifa katika kikao hicho, na itakuwaje kwamba ripoti hizi zianze kuibuka baada ya mwaka ama miezi kadhaa?
Na mtazamaji wangu, bila shaka picha ambazo unazipata moja kwa moja ni picha za pale Milimani mahakamani, ambapo tunaona naibu wa rais aliyeng'atuliwa kupitia bunge la kitaifa na la seneti amewasili, pamoja akiwa na jopo lake la mawakili. Wanaonekana kusemezana tu, ikiwa ni dakika zao za mwisho kuweza kupata uamuzi wa ikiwa naibu wa rais aliyebanduliwa mamlakani ana nafasi ya kuweza kuendelea kupambania afisi hiyo, ama ndo hivyo kesi hiyo itatupiliwa mbali. Na ikiwa hilo litafanyika, basi moja kwa moja naibu wa rais mteule Kindiki huenda akaapishwa siku ya leo. Hivyo basi hizo ni picha za moja kwa moja, lakini nije kwako Kani. Kuna ambao wana mtazamo tofauti. Wanasema masuala ambayo naibu wa rais aliweza kuzungumza siku ya Jumamosi pengine yatatoa mwongozo